but it looks like it's 2 o'clock. My name is Sean Suter. Hi, welcome. I've been asked to give a talk about inventorship, and so that's what I'm going to do. I'm a patent attorney here at Suter Swantz, and I've experienced over the years, the last 30 years, a number of inventorship issues. So this first slide is about this young lady, Gitanjali Rao. And in 2017, she was 11 years old, and she'd read an article about the water crisis in Flint, Michigan. And about that same time, she had seen that carbon nanotubes could be used to detect hazardous gases. And so she put those two ideas together, and she came up with a solution to at least determining how bad the water in an individual household was for those people living in Flint. She was named an American Top Young Scientist and was a Forbes 30 under 30 person, I think in 2019. And here Time made her the Kid of the Year. So I love stories like this. And the question here is Gitanjali an inventor under the patent laws? And so let's continue on, and we'll try to answer that at the end. So who and what is an inventor? Well, we're all familiar with Gutenberg, Franklin, Edison, Bell, Carver, Tesla, Berners-Lees, and maybe even Hedy Lamarr. We know these people to be creators and pioneers, and designers, makers, builders, founders. We have lots of great words to describe these people, and they are often labeled inventors. But the popular press really likes to talk about inventorship in a way that portrays inventors as screwballs or eggheads or eccentrics. I think of Flubber and those Disney movies, the computer wore tennis shoes, things like that. My favorite is The Man in the White Suit, starring Alec Guinness from 1951. If you've never seen it, it'll tickle you to watch it. I would encourage you to do that. I've often thought, as a patent attorney, that I'm offended by the popular press, and those of you who know me know that that's true. And that old adage that if you're a hammer, everything looks like a nail. Well, when you're a patent attorney, everything looks like a patent problem. And so when the press comes out against inventors, I think it's kind of a modern thing, and I hate to have inventors suffer. But it's actually quite old. Here is some text from a letter that Benjamin Franklin wrote in 1755. And I've thought about trying to summarize this and not including the actual text, and I've thought about having you just read it. And I guess I'm going to just read it to you. And I know that's probably verboten, but here goes. There are everywhere a number of people who, being totally destitute of any inventive faculty themselves, do not readily conceive that others may possess it. They think of inventions as of miracles. Everyone who offers a new invention is deemed a pretender. A man of their own acquaintance, one who has no more sense than themselves, could not possibly, in their opinion, have been the inventor of anything. The smaller your invention is, the more mortification you receive in having the credit of it disputed with you by a rival, whom the jealousy and envy of others are ready to support against you, at least so far as to make the point doubtful. Had the invention been greater, it would have disgraced you less, for men have not so contemptible an idea of him that robs for gold on the highway, as of him that can pick pockets for halfpence and farthings. One would not, therefore, of all faculties or qualities of the mind, wish for a friend or a child that he should have that of invention, for his attempts to benefit mankind in that way, however well imagined, if they do not succeed, expose him, though very unjustly, to general ridicule and contempt, and if they do succeed, to envy, robbery, and abuse. I think that's true. It's hard to be an inventor. It's hard to have an idea. I've often portrayed them as being kind of like soap bubbles. They're very easy to pop. And inventors tend to be artists or artistic in nature, and so they have a hard time owning and then presenting their inventions and having them shot down. But at bottom, I think we're all inventors, that it's in our DNA, and that our social constructs either encourage or discourage invention. In the United States, you know, Yankee ingenuity, but still there is this nagging backdrop of our ridicule of inventors. I also think and believe that inventorship can be taught, that it's basically the application of the scientific method and engineering skills, and that all inventions, once they're complete, are trivial, because everything's trivial after you've done it at least once. And that's why in determining whether something's patentable, we're not supposed to use hindsight, but it's very difficult not to do that. So patents are not necessarily earth-shattering. They're just basic improvements to other ideas. All inventions are combinations of known elements, but they can't be abstract concepts to be patentable. They have to solve a technical problem. They can't be just a path to a particular solution or a jumping off point for further research. They're not a fishing license. The public policy of each country's patent system, or those policies, is embodied in the legislation that provides for taking something out of the public domain and giving a limited monopoly on it. And so, who is an inventor? Well, it's somebody that conceives and reduces an invention to practice, and that can be either constructively or actually. Generally, in the popular press, which is not the law, it's a label. You don't call yourself an inventor, at least that's been my experience. It's a label that's given to you. And that's why most inventors are dead. Sometimes they are precocious teens because they sell newspapers, but they are very endearing and they provide a lot of hope, I think. It's also sometimes a pejorative. It's a way of calling somebody a pretender. It's also a way of feigning outrage in a virtue signaling way. Like if you go to some of these Apple-centric websites, anytime anybody sues Apple, there's a lot of discourse about how evil the patentee is. If you are only moderately successful, in other words, you haven't been able to generate revenue on your own and you're suing somebody for infringement, then you're definitely a troll in the popular press. If you are successful, other labels generally apply. But most commonly, scientists and engineers are inventors when they work in product development. That's what they do. That's their job. But it's also laborers trying to make their jobs easier by just, new tools, new steps, new ways of working in a kitchen or a factory or on a job site. But it's also small business owners that are trying to get an edge over their competitors. So again, under the patent law, an inventor is somebody that conceives of an invention. The first statute under Title 35 is whoever invents or discovers. And the case law repeats something like this in all of the cases. Conception is complete only when the idea is so clearly defined in the inventor's mind that only ordinary skill would be necessary to reduce the invention to practice without undue extensive research or experimentation. Let's think about Ms. Rowe in that context. The popular press, again, also has created this social stigma that we all live in. Maybe we're born with it too, I'm not sure. But we want to share our discoveries. It's part of our human nature. And sometimes we include supervisors or partners or everybody that was in the room as a named inventor. But collaborators and bosses and mentors and co-authors aren't always inventors. Sometimes they are, sometimes they share in the conception. And investors and patent attorneys rarely are, but you know, you do see this. This case, very interesting, Mueller Brass Company v. Reading Industries. The judge said, one of the muddiest concepts in the muddy metaphysics of the patent law. And Justice Potter Stewart, we all know, said, but I know it when I see it, when he was describing poetry, or excuse me, pornography. In the United States, the basis for the patent law is found in our Constitution, Article 1, Section 8, Clause 8, where it gives Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Notice the Constitution authorizes issuing patents only to inventors. This is very unique. Every other patent system allows patents to be issued to applicants or entities. And in fact, naming the inventors is not really a requirement. Although some jurisdictions like Germany and Japan and China do require that the inventor be remunerated in some way. So the statute that Congress passed to describe inventors is Section 116, and it does talk about joint inventors and how they don't have to work at the same time in the same place and have equal contributions. And it talks about what to do where an inventor is omitted and how to correct errors in a patent application. But back to the Mueller Brass case, it doesn't really describe it as a test. But it is really a test, is whether somebody has fully formed a concept or a solution in their mind, and they've conceived of it. But it's going to change over time. Why does that change? When you identify the source of a problem and come up with a solution to that problem, you don't necessarily know what the prior art is. Although some inventors are so prolific and they work in such a small area that they do know. But generally, a person wouldn't know what all the applicable prior art was because they haven't gathered it and read it and understood it. They've also probably not built a prototype or otherwise tested their invention. They have no reaction from consumers, people that have tested it. They have no feedback from anybody that has assisted in reducing the invention to practice. And because they haven't filed a patent application, they don't have an office action from the United States Patent and Trademark Office commenting on the patentability of their invention. Again, reduction to practice is not inventive, but it's a required component. You have to reduce your invention to practice either constructively by filing a patent application or actually by building it or practicing it. Another case says the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is thereafter to be applied in practice. So that could happen all at once, but I hope we can all see that it could happen over a number of years, and that you may not know who the inventors are until you finally issue patent claims. And you may be dissatisfied with those claims, and you may feel like there are better claims to be written within the specification. But the claims themselves are what define what the invention is. It's not the specification. The claims are an embodiment, or the specification is a listing of a number of embodiments of the claims. The claims are the property right, and they do describe the invention. There's a famous case dealing with Samuel Morse right after the Civil War, where Morse had a claim, I think it was claim 7, that claimed communication with the use of electromotive forces. And of course, the Supreme Court invalidated that claim and others, primarily because they knew that the invention, the specification for that patent, didn't describe every means for communicating using electricity. That Morse had not invented the telephone, or television, or texting and whatnot. So the parameters or the breadth of the claims is certainly defined by the specification. but the conception is what is in both the claims, and the breadth of that conception is described by the specification. And that can mutate over time. So this happens a lot, where joint inventorship occurs. Sometimes there's 6 or more inventors, and it's hard to really understand how that might work, but having sat in those rooms where it has happened, you begin to understand it. So what are joint inventors? Well, we know from the statute that they don't have to make equal contributions. They don't have to contribute to every claim. They don't have to physically work together, and they don't even have to work contemporaneously. Also, just because the boss is in the room doesn't necessarily mean that the boss is the co-inventor. The most popular person, she doesn't necessarily have to be named as an inventor. She has to be if she conceived of and was part of fully forming the idea or the solution to the problem. And entity ownership has nothing to do with inventorship. In the United States, entities are never inventors. They are applicants. In other countries, they're considered applicants, but not the inventors. There is a distinct difference between inventorship and ownership. I don't know why this is confused a lot. I suppose it's because inventors are the owners. Under the pre-America Invents Act, inventors were deemed to be the owners absent an assignment. Now the applicant, after the AIA 2012, is considered to be the owner. So they are distinct concepts, and ownership enjoys rights and benefits that inventorship doesn't necessarily enjoy. There is this equitable right called shop rights that provides, even absent a written agreement between an employee and an employer, that the employer may own the invention. Patents are personal property statutorily under Section 261. Congress tells us that patents have the same properties or attributes of personal property. And what are those? Well, the owner can exclude others from benefiting from the patent, and they can use the invention, but there are some limitations to their ability to use it. Just like with other personal property, you can lose your driver's license and not drive your car even though you own it. If you have a patent, you can't necessarily practice it because there may be a dominant patent out there that you would have to have a license or pay royalties in order to practice, or there may be some FDA requirements that, or you name it, some regulatory scheme that precludes your practicing the invention. Another attribute is controllability. There's either a legal system or force that can intervene and prevent trespass and assist owners in controlling their property. It's also transferable. This is very important. I think I already talked about how the AIA presumes that the original applicant is the owner, and before that it vested ownership with inventors. Assignments are governed by local law, state law, but patents are recordable with the United States Patent and Trademark Office. They can also be part of a uniform commercial code filing in states, but a recordation with the United States Patent Office is required. Otherwise, an assignment can be voided against a bona fide purchaser for value if the written assignment wasn't recorded within 3 months of the application date or the occurrence of the assignment. So the inventor versus the owner. Well, an inventor is a person that has dominion over an idea related to solving a problem. Sometimes the identification of the source of a problem constitutes an invention if it's coupled with some obvious solution. Maybe the solution is obvious once you identify the problem. Generally, after the conception, there must be evidence or a showing, in looking at all of the cases, that the inventor, the original conceiver, maintained dominion over the invention during the process of constructively or actually reducing it to practice. Patents are property. Patent applications are property, and they're inchoate. In other words, they're not actually property. They're just capable of becoming property. They also have, in my mind, a very unique characteristic of as compared to other forms of property. I love this quote from Thomas Jefferson. "He who receives an idea from me receives instruction himself without lessening mine, as he who lights his candle at mine receives light without darkening me." Whereas an owner is somebody that has dominion over a thing, which sometimes can be intellectual property. So again, if inventors file a patent application, one or more joint inventors, they are the owners, and they own the property and as joint owners, not as tenants in common. Most inventions are owned by an entity, and why is that? It's because I think inventing and exploiting inventions is very expensive, and it requires a broad skill set. So you need to have people with different skills on a team to make it actually work, and that's done through an entity. Joint ownership. So if there's no agreement between the owners or the inventors that's written, then each has an undivided interest in the whole, and without the consent and without accounting to the other, they can exploit the patent. So it's important to, in representing inventors where there are multiple parties involved and some may or may not be inventors, to memorialize the ownership as early as possible. You can correct inventorship. You can correct inventorship of a patent application, and you can correct inventorship on an issued patent. A patent that issues with the incorrect inventive entity named is unenforceable. Generally, I've found that non-joinder is more difficult to correct than misjoinder. If, in other words, you can take somebody off more easily than you can add somebody. It used to be a requirement that you showed that there was no deceptive intent and you were diligent in order to correct both. And the affidavits and the type of information that you had to have as proof of that for adding someone who wasn't originally added was more onerous than taking somebody off. There are really 5 paths to correcting either an application or a patent. You can refile, but that, of course, requires that there be copendency and that there is some overlap in inventorship. You can file a petition. Even though deceptive intent is no longer a requirement or a factor, you still have to state that. You can also seek a reissue. There is a requirement for diligence, and if you want to broaden the scope of the claims, you have to do it within 2 years. You can also do it through a certificate of correction. I've never been successful at that. There's also a path through the district court, which I've never done, but there's a statute that allows you to correct inventorship by asking a federal district court judge if she'll correct the inventorship. So, Gitanjali Rao, is she an inventor under 35 USC section 116? I'm told I can go up here and see if there are any questions. So does anybody have any questions? So she's an inventor, right? She conceived of this invention. The bit about does she know how to 3D print a box or design the box and 3D print it? Could be. She's a modern preteen teen. Does she know how batteries work? Does she know how Bluetooth works? She probably does, doesn't she? Carbon nanotubes, all she really needs to know is that they can detect different elements, and she can test to determine their efficacy in detecting lead and ways of getting lead, water that has lead in it through those nanotubes. But she does have a lot of help. If you listen to the NPR All Things Considered report, you know that she's working with some good people in reducing her invention to practice. So I think that she's definitely an inventor under the law. Do I think there are potential co-inventors? Well, you'd have to know more about how she's worked with her. Maybe they are collaborators. Maybe they're doing more than just reducing the invention to practice. Another interesting question is could she file and receive a patent on her application if she waited to file it today? And she couldn't, could she? Because she would be barred from doing it. It would have been on sale or publicly disclosed. And there's also the question that if she had filed a patent application, let's say soon after she had conceived of it, and maybe as a constructive reduction to practice, she filed a patent application, who would own the patent? Well, along the pathway, she may have been required to sign a number of documents, like to work in the lab of the Denver Waterworks person. And so that would have to be determined. But I think she's an inventor, and I love that. So, summary. Inventorship requires conception, and it has to be coupled with either an actual or constructive reduction to practice. And I think Ms. Rowe's case is a perfect example of that. The inventor doesn't need to know necessarily how to, what components they'll need and how to piece the components together. They just need to know generally and have a full picture generally of how their invention would work. Joint ownership and inventorship has consequences. It creates an undivided interest in the whole. So agreements memorializing what the ownership actually is are very important. Inventors aren't necessarily owners, and owners aren't necessarily inventors. Misjoinder is easier to correct than non-joinder. And ownership issues should be resolved and memorialized early. Does anybody have any questions? I feel like maybe I rushed through all of that. So I hope you have some questions. I'll sit here and drink my tea. Maybe I just did a really good job. So, what are my views on patent attorneys claiming to be an inventor? I don't know why, I'm just disgusted by it. But I sometimes consider myself an inventor, and I'm a co-inventor on at least a dozen patents, and I feel legitimately so. I also have assisted in defining the bounds of inventions for clients. And I don't think, as a matter of fact, I'm sure that doesn't make you an inventor. And it does seem campy to name, for an inventor to name, for a patent attorney to name themselves as an inventor. But again, it's a legal statutory test. So if you are an inventor, you need to name yourself as an inventor. I can't imagine how that might, what those conversations might look like. It might be very difficult. I think if I thought it was going to be difficult, I would just make sure not to claim anything that I thought I was the inventor of. So here's another question about correcting inventorship under 256 and how it does not exclude deceptive intent. Have you seen this have any impact on organizations when making inventorship decisions? No, I haven't, but it comes up a lot. You know, just in the last 2 months, I've had 3 different inventorship matters come up. One was an individual that was doing the drawings. They were an employee of a company and junior to the inventor. And they had been working long hours and reducing the invention to practice. And so they were added as a co-inventor by a very sophisticated lead inventor and business owner. And that co-inventor left. And so now that person needed to be removed as an inventor. It also came up in some cases where some of the inventors were from France and some of them were from the United States. And the laws in the 2 different jurisdictions obviously are very different. And figuring out who to name as the inventors, there were a number of cases, there were like 8 or 9 or 11, and they were all related, was still an ongoing process. There are also export control laws and foreign licensing requirements that come up a lot. Cases have to be filed first in the jurisdiction in which the invention took place. So generally, Sarah, I would say that even though it's not a requirement to allege that there was no deceptive intent, and even though it does appear, it's always the best policy to do the very best job you can in correctly naming the inventors and be filled with that righteous indignation that one has when they did the right thing at the time and are forced later on to make a change because there is a change that would require a change in the inventorship. Anything else? Well, that was fun. I'm glad it's over. I think I'd do this again. Oh, there are more questions. For some reason, I can't see them. Sorry. You all know how to get a hold of me. So for those 3 other questions, call me or text me. I'll be glad to answer your questions. Thank you very much for attending. I hope it gets warmer soon. Goodbye, everybody.